Saunders, and I'm excited today to be presenting to you our inaugural webinar, and hopefully the first of many, on successfully navigating the New Zealand building compliance process. I'm delighted to have Lupe Menezes from Auckland Council join as our panelist, and hope that you will learn something new from today and certainly challenge the way in which you think about your building warrant of fitness process. Just a couple of housekeeping notes before we commence. We will be taking some questions at the end of the presentation, so please submit these through the questions button on your webinar. We've also made available under the handouts a PDF version of today's presentation. Otherwise, everyone's on mute throughout the course of the presentation. So we will commence. So my name's, as I said, Fiona Saunders. I'm from WSP. I am the work group manager for property and projects based in our Auckland office. And our building compliance team forms part of this team. My background is in property and facilities management, so similar to many of you on the call today, and really want to ensure that health and safety is paramount to our clients and by extension their properties.
Morning everyone, my name is Lupe Menezes and I'm the Building WOF team leader for Auckland Council. I'm excited to be part of this webinar, and I'd like to just thank WSP for providing the opportunity to be able to present today. I have been with Auckland Council for approximately 10 years in various regulatory services divisions, and I've been the Building WOF team leader for approximately 2 years now, but my background is compliance, so I'm looking forward to this webinar and what it holds.
Thanks, Lupe. Zared Coburn, building consultant, compliance consultant for WSP. My background is I'm an IQP, specialising in mechanical and air conditioning ventilation, and I'm registered with Auckland Council.
Great, thanks Zared, thanks Lupe, much appreciated for you being able to join us today. So why have we put this presentation together, this webinar? Primarily it's to help share knowledge, but also importantly to challenge the status quo on how we work with our building warrant fitness agents and by extension our local authorities and councils. We want property owners, their building agents, whether it's facilities managers, property managers, building managers, to consider the building warrant fitness agent as a trusted advisor and someone that you maintain regular communications with, and indeed your first point of call when you come to do either consented or unconsented works. We're hoping that during the course of this presentation we will demonstrate tangible benefits by having a more collaborative, communicative relationship between the two parties. So what is a building warrant of fitness? Well, in simple terms, this is the annual health check for a property and issued to the local territorial authority. It's a requirement mandated under the Building Act of 2004 for a building owner or a building owner's agent. It falls on the anniversary of the issuance of the compliance schedule, which effectively is the life safety for the building. And it's a confirmation of all the compliance schedule requirements have been met for the prior 12 months. And we'll talk through what a compliance and what comprises of a compliance schedule for you. We really want to make sure that this isn't just a set and forget process, and that there really is some further collaboration with your agents. So, sorry, So when you're next in your buildings and when you next go to the doctors, the mall, the next commercial building that you go into, just take a look around, and they're often displayed in the common area, but this is where the certificate, your annual building warrant of fitness, will be housed, located. And just go and check the expiry date, because oftentimes you may note that unfortunately some of them are expired, and who undertakes it. So challenge you to do that. Have a look for it the next time you enter a building. Over to you, Zared.
Good. The benefits of the New Zealand compliance system and making this as the first thing is safety. So we'll touch on this in our presentation, as we believe this is a major factor in the BWOF process, and also downtime and disruption. We want to stop this due to there'll always be maintenance and testing carried out, and to pick up any of those issues and faults. And so why is this all important? This enables the BWOF to be delivered faster, which means you will have a valid building insurance as well, because a lot of people don't know that it's invalid if you don't have a current BWOF. This reduces technician man hours on site as well, and then also stops fines, because territorial agencies have the means to start fining people. And this is why we think it's so important that you engage with your BWOF agent and your IQPs. So what is an IQP? An IQP is an independent qualified person, and an IQP must have a background and experience in their particular specified system. So for Auckland example, you go on their website and you can find all the IQPs that are registered and what the systems are registered for. And most importantly, what are the owner's responsibilities? You can see that we can send you this guide that shows on the screen that shows the responsibilities, and it's produced by the Building and Housing Association or Organisation Department. This is something that you on the call should pass on to your local and overseas owners to make sure that they know what their responsibilities are. So Lupe, why is this owner's responsibility document so important?
Thanks, Zared. This particular document, which was released by the then Department of Building and Housing, which is now the Ministry of Business and Innovation, was a document specifically put together for owners to kind of understand the actual BWOF process as a whole. It actually starts right from the beginning, so it's really important because it covers everyday situations and scenarios. It also details the legal responsibilities in line with the Act for owners and, well, actually for owners of buildings that contain specified systems. And it actually allows you to apply real world situations and scenarios to your particular building and what you're required to do. So I highly recommend this, this document, and Auckland Council will also be sending these documentation out when we receive applications for new compliance schedules, as well as amendments to compliance schedules via the Form 11 request. So.
I'm glad you brought up real life perspective to that, so I'm glad that Council have a perspective on this. So what is a specified system? A specified system helps ensure the safety and health of the people that enter, occupy and work in a building. They require ongoing inspections and maintenance to ensure they function and as they require. If they fail to operate properly, they have the potential to affect health and life safety. And so just looking at this list, touching on certain things like fire, mechanical,
And I note that single residential buildings, it applies to if there is a cable car present. Just Lupe, out of interest, are there any such buildings that fall into this category in Auckland?
Thanks, Fiona. Yes, there is actually. I believe that Auckland, the Auckland region has somewhere in the vicinity of 11 plus single residential homes that do actually have cable cars. So yes, we do have them.
Interesting. Well, I've certainly learned something new there. Just for those on the call that may deal with body corporates, and just a watch point, having recently been to site for a body corporate, small body corporate, 2 stories. They had a combined fire system or centralised fire system and lift, but they did not have a building warrant of fitness for the building. So just make sure that all your clients are complying as required to do so.
And passive fire, as it appears to be a hot topic currently. Lupe, passive fire 15 and emergency power systems 14 do they appear on most compliance schedules?
Yes, Zared, they do actually, especially 14.2 and 15's your final exits and your signs for communication to facilitate evacuation, so 15B and 15D. They're very popular on most compliance schedule. Passive fire is now becoming quite a big, as Fiona said, a big topic of conversation. So yes, we do have them, and yes, they're throughout the whole Auckland region. And
a council perspective in terms of passive fire, what should building managers keep in mind when it comes to passive fire?
Passive fire, the building managers need to be very aware of the fact that if we have certain things like fire separations, which is your 15.3 or your 15Cs, if you have any plans to renovate or extend or alter any of the passive fire systems, please check to the extent of the building where those actual systems lie, because they may potentially, if not considerably, affect the performance of that particular system. So please liaise with your building WOF agent to actually get advice from them as to your potential plans in place and how that may affect the building warrant of fitness moving forward.
Thanks for that. I know a lot of people have a lot of questions about passive fire, so thank you.
And just to reiterate, that need for communication and also for property owners to maintain good records of as-built and refurbishment plans.
Totally. What is a compliance schedule? So some of you may or may not have seen this. It is created mostly after consented works are completed and lodged. When you have a property, when you get a property on board next, check all the building details are correct. In our experience, check the lot numbers, make sure there's no little tinkerings with the address, and make sure all the specified systems are correct. And make sure you're to assign an IQP to manage, maintain, and test these systems. Just note as well, this is not the whole document. There is a manual with performance standards that should accompany this as well. So Lupe, do you see any information that's like a lot of the time that's wrong on compliance schedules?
We do. I wouldn't say that they're wrong. They're probably just more likely they just need an update. There is information relating to the specified systems that we need to keep and record on. And so what basically the compliance schedule is a inventory of the life cycle of that particular building. So if you've got specified systems running throughout, and as the building has developed over the years, change of hands, change of alterations, etc., etc. We want to kind of document what's happened to the system as the building has undergone changes. So a compliance schedule is the best way to maintain and monitor that. You'll get the odd errors here and there in relation to perhaps a legal description, and that could basically be simply put down to the Auckland Isthmus itself is actually growing as a whole. So you'll see a lot of subdivisions, you'll see a lot of properties, you'll get large pieces of land that are being sold off individually, etc., cut up and sold off. So you will need to make sure that what we have on file is actually correct. So that's why we really encourage that owners liaise with your BWOF agent and just say, hey, there's something on my compliance schedule that doesn't look right. Could you supply a Form 11 request into the council to change my compliance schedule so it's actually pointing where it needs to sit?
So Lupe, you mentioned changes and like, what do we do when we have an older building and performance standards have changed and perhaps those aren't necessarily denoted on the original or on the current compliance schedule? How do we manage through that?
Thanks, Fiona. Look, when compliance schedules are issued on the outset, so if we took a scenario where Joe Bloggs had a building which was built circa prior to the 91 Act coming into force, so it's around about 1950s, 1960s years of age. In 92, when the requirement for a compliance schedule came into law, all owners of buildings that had specified systems were required to apply for a compliance schedule. So they would have had to obtain from either themselves or from the property file itself information relating to those specific specified systems, and at the time it would have been installed to a particular standard or a building code clause, etc., etc. So when the compliance schedule would have been put together and then issued out, it would have been closely aligned to the performance standard at the time. So therefore, standards will change and have changed over the years. So if we took, for example, fire alarms, so 4512 is the standard that everyone would have been looking at, or will be the standard that everyone needs to look at. But if it was installed prior to the 1970s, then you would use that performance standard as the standard to which the alarm will need to be checked against. Unfortunately, even though standards have changed, you wouldn't be able to apply the current standard to the system because it was installed prior to the new standard being where it is at the moment. So currently at the moment, 4512 is sitting at a 2010 as being the most current version of that performance standard, but the compliance schedule will actually point to it being the standard at the time that compliance schedule or that system was installed.
So really, again, it's just keeping that line of communication, and if we require a full compliance schedule, a copy from the council, we can email off and request that.
Yes, certainly. Like I said, buildings will obviously evolve over time, and people will make changes to building to suit tenants as and when they come and go. Sometimes those systems will be extended, and then the extension portion of the system will fall to the current standard, but the actual existing system itself will be applicable to the previous standard that at the time that it was installed. So it's really, really important that again, owners, if you want to make changes to your building, your first port of call really should not be your architect it should really be your BWOF agent, because they will be able to tell you how any kind of work to a building can affect the compliance schedule, and therefore implement, will actually affect the BWOF in 12 months' time. So.
Right. And I think that's a good segue, Zared, into what is a Form 11.
Yeah, Form 11 is our IQP or owner may recommend to amend the compliance schedule, and they do this by using a Form 11. Then the council make the final decision to amend or not to amend the compliance schedule. And if the council accepts the recommendations, then they will make the necessary changes to the compliance schedule and amend the compliance schedule, and that will be sent back to you. Lupe, in legal terms, sorry, does the Form 11 when does it need to be produced?
So I believe if you go into the Building Act 2004, there is a section of the Act, I believe it's either section 106, is when an agent or an owner can make an application through to the council for an amendment. Section 107 points to when the council or the territorial authority can actually amend, but prior to the council actually making any amendments, they need to notify the owners of the property. So I believe there is a legal requirement and a time frame within which you can actually apply for an amendment to your compliance schedule, and I believe it might be section 106 of the Building Act. So
that's interesting. And just to follow on to that is the role of councils in this whole partnership. So what are the roles of councils in all of this?
That's a really good question. I think one of the things that we really need to kind of put out there is the building warrant of fitness regime, as outlined in section 108 of the Building Act, is a process or a regime that is indigenous to New Zealand. New Zealand is the only country right now that actually has this process in place, and what we're trying to do is we'd like to get to a point throughout this time to be able to be an exemplar or an example to other countries in trying to implement something similar for them. Look, obviously, if New Zealand has actually put this into place, for us, it's kind of saying to the world, we actually care about the people that work and use and come in and out of these, or lease and tenant these buildings for us, and so their safety, both health and health and life, I should say, is really important. So we get, needless to say, I can't speak for other councils, but being one of the largest, or if not the largest council in the whole of New Zealand, you can imagine that we do have our fair share of frustrations, both from a territorial authority point and also from owners and agents and IQPs in the industry as a whole. So we are trying to actively, for Auckland Council themselves, we're actively trying to work with the industry to be able to educate, provide advice, and also, notwithstanding, also administer and enforce the regulation that we're actually bound by under the Act. So it's going to take a lot of collaborative effort, not only from owners, but also from within the industry and from other councils as well, to just all work together and just make this a process where people are, going to be comfortable going into buildings and knowing, yeah, this building is safe, so I can do what I need to do, and I know that in the event of an emergency, I can get out of this building and I can safely evacuate. So.
Thanks, Lupe. And I just want to add with that, with some people on the webinar may have buildings in multiple cities and different territorial agents, and they will have different processes. So just be aware of this. So this is a 12A document that you get from an IQP. Some tips and tricks to look out for when you receive one of these. Check that it's signed and dated, and all the details are filled out. It can't be signed for an annual check over 30 days before the BWOF expires. So people aren't aware of this, but you need to make sure that this is correct. And why is this important? Because this is a signed legal document, and so all information needs to be correct. Lupe, what happens when you receive a 12A that doesn't have the correct details on it? And the time limit for resubmitting.
Okay, so if council receives a 12A certificate that is incorrect, it all depends on the situation and the scenario and the reasons behind why it's why we believe it's incorrect. It could quite possibly come down to that they haven't actually carried out 12 months of full checks. There could be a number of reasons why the IQP could be expired. So there is a time to resubmit the 12A certificate, but here a point of order would be a 12A should be accurate when it's sent to the owner or the owner's agent in order for that to be forwarded through to the council, because your Form 12, which is your warrant, cannot be issued until you've received all 12A certificates. So just be aware that really all your IQPs need to have, definitely can, without a shadow of a doubt, be able to qualify and quantify the compliance statement made on the bottom there, which says the inspection, maintenance and the reporting procedures of the compliance schedule has been fully complied with during the 12 months prior to the date, etc., etc. Please make sure that they can actually qualify that statement, and that in signing it, they're declaring that the statement is accurate and true. It is a legal document. Anything outside of this or included in this could be deemed fraudulent or could take the form out of context. So just be very, very mindful of the Form 12A and what you're actually signing, or what your IQP is signing.
So Lupe, you've touched on that. So in the instance that we've, as a building warrant of fitness agent, we've received an all bar 112A, I'm just clarifying, we cannot submit for a building warrant, can we? We have to wait till we've got all 12As in.
Yeah, correct. Section 108 is fairly clear. You have to supply an annual building warrant of fitness on the anniversary. If you go to section 108.3C, it will also tell you you need to supply a Form 12 and all 12A certificates and any other certificates and documents that considered together will, fulfill a 12-month period. So if you don't have all 12A certificates, then you cannot satisfy that requirement.
So for those on the call and my previous experience, I would challenge you to just, when you're working through the annual building warrant of fitness process, if you do have expired building warrant of fitnesses, that you are speaking with your insurers regarding that. As we touched on earlier, it may be a case that without a current and valid building warrant of fitness, you may be impacting the validity of your insurance. The other point to note is oftentimes your building warrant of fitness agent does not directly engage the IQP contractors who maintain and produce the 12As. So therefore, they don't have the carrot with which to use the stick, so to speak. So again, it comes back to being proactively managing those relationships rather than being reactive and trying to follow up 12As in a very short, which is often short period of time. Getting ahead of that and having that open line and collaborative relationship with your building warrant fitness agents, contractors alike, so you can address any remedial or defect notices. The other point to that is if you do receive, as a building manager, property manager, facilities manager, or certainly owner, any remedial notices for works. So oftentimes contractors will advise that they can't issue a Form 12A until works are undertaken. Do engage with your IQP, your building warrant fitness agent, and challenge those. Oftentimes they are still able to issue a Form 12A ahead of any works being done. So again, ensuring that you've got that communication, that line of communication, and really it is not, we're looking at changing this up, so it isn't a set and forget process. Anything else, Lupe, from your side, just to add on that? Oh, actually, I often hear, what's a report in lieu or a RIL, as they're often referred to? Can you expand on that?
Yeah, thanks, Fiona. Okay, so a report in lieu is not a prescribed form, but it was a process, or is a process, that Auckland Council currently has. I'm not too sure whether there is a few other councils out there that actually have something similar in place. So a report in lieu is a report sent in by the owner or his agent when an IQP is unable to supply a 12A certificate. How the process should really work is under Section 110 of the Building Act, all owners need to request from their IQPs an annual report for the systems that they are maintaining or inspecting or reporting on. And that annual report submitted in from the IQP will give the owner at a glance a review of the system in one whole year. So it should list what the system is, how often it was being inspected, any issues that came as a result of any of those inspections, and whether any of those issues were reported to him for him to actually undertake any kind of work, whether it's approving for funding to be provided, or a quote that needs his sign off on, etc., etc. So an IQP, if he is unable to supply a 12A certificate, would send the annual report to the owner, and then the owner would look at it. If he's the one issuing the Form 12, then he could potentially look at using the report in lieu process as a document that he can supply in lieu of a prescribed Form 12A. Or if he's not the one issuing the building warrant of fitness and he's engaged in an agent, then what the agent can do is he will take receipt of the annual report, and he will decipher or determine from that the issue as to why the 12A could not be issued, and then they advise the council via the report in lieu what the issue is and the reason why that particular IQP could not issue a 12A certificate for that particular year. Please note that a report in lieu process is not a process that all councils currently have. Every council is different. There may be some that do have a process similar to this in place, but subsequently, on the other hand, there are also councils that don't have anything like this in place, and so therefore, but this is Auckland Council's process, and we do have reports in lieu.
Great, thanks for that, Lupe. And just on the just a question around the recent challenges for COVID. I take it there may well have been some reports in lieu issued during lockdown for the lockdown period for BWOF expiries during that period of time.
Yes, there was, Fiona. So when COVID came into place, the Ministry of Business and Innovation released 2 particular documents that owners and agents and IQPs could supply to the council in lieu of a building warrant of fitness and 12A certificates for missed inspections because of COVID-19. The thing that we need to be mindful of is that that particular process released by MB was guidance and guidance only. It was up to the individual councils to apply where necessary processes that, if not, they already had in place, or look at implementing what MB has released. The Auckland Council stand is fairly much the same. We already have a process, which is what we just spoke about, which is the report in lieu process. We have that process in place already. We're not going to not accept BSSRs and SSRs. If you do opt to want to submit through to Auckland Council a BSSR or SSSRs, as per MB, then what we're simply advising owners and agents is respectfully, then you'll need to supply it as per MB's guidelines and rules given to them when they release the media or put out that media release. But you can't mix and mingle the current report in lieu process for Auckland Council in with MB's because you're effectively, what you're doing is you're actually trying to merge together 2 separate processes. So and at the same time, we also need to remember that a BSSR is effectively saying that that building does not have a building warrant of fitness. So it's a very fine line, but we don't process the BSSRs as actual renewals because they're not actually renewals. It's a declaration being sent in to say that this building does not have a building warrant of fitness because of COVID, and for one or the other, the reason is we couldn't carry out full checks, etc., etc. And we will process those separately from our BWOF renewals, etc. So.
Great, thanks for that, Lupe. And really important to note the difference between the SSSR piece and how that's treated by councils, and the takeaway that each council will deal with COVID-related and MB guidelines differently. So in summary, and just to reiterate the key takeaways that we would like to put across to our audience today is really looking at the whole end-to-end process of obtaining your annual building warrant of fitness slightly differently, rather than I said a set and forget process, actively engaging with your building warrant of fitness agent and by extension the council to ensure that you have open dialogue, you can address any defects that may arise during the course of the year, or any works that may be undertaken ahead of the annual expiry of your building warrant of fitness, so they're dealt with in a timely manner. Property is an investment of typically high value, so it's making sure that the building warrant of fitness agent is treated in the same respect or held in the same regard as many of your other contractors that you have working on a building on a day-to-day basis, often on a day-to-day basis, and just having that open line of communication and sharing the owner's responsibility manual with your clients. I think that's really important, because oftentimes, particularly people that invest in property and it's not their core business, do not fully understand what their requirements are, and particularly as this is statute under the Building Act. So we hope that we have imparted some information that you may not have previously been aware of. We hope that you go away and think about changing how you work through the annual building warrant of fitness process. We would welcome some questions now. So I think, Zared, we've got a couple of questions that were submitted as part of the registration.
Yes, we do. We've touched on a bit of COVID-related stuff. So if anybody has any questions regarding the problems with COVID or it's affected their building, you can put them on the chat. So we got questions from registration. So one from Justin, directed at Lupe, which we've kind of covered. We get a number of service agents issuing 12As in lieu to get a BWOF issued. Is this a legitimate practice?
Yeah, so Justin, yes, it is a legitimate practice. It was a process that was introduced back in 2005, and it was acknowledged and realised that there were certain situations and scenarios where an IQP would not be able to supply a 12A certificate. For example, a change of service contractor midway through an annual renewal period. So the Auckland Council, after discussions with the industry, decided to come up with a process that would allow them to be able to still send in a document that, if considered by us, would satisfy the requirement of supplying a 12A certificate, and so therefore the report in lieu process came into play. So yes, there are legitimate reasons and genuine reasons why a 12A certificate cannot be issued, and as I said, that's why annual reports are really, really important, because then you'll be able to see the reason why that IQP was not able to supply a 12A, and why you or the owner or the owner's agent is now going to be supplying a report in lieu instead.
Thanks, Lupe. We got another one from Craig saying, what to do if remedial works may be found, but council only allow 12As to be dated 4 to 6 weeks before the BWOF is due.
I think a lot of this kind of stems through, while we don't have any mandate over when an annual inspection is undertaken, we do have situations and scenarios, and I have spoken to a few of the agents in the industry where they tend to take the annual inspection towards the end, approximately 4 to 6 weeks out before the BWOF is due, and it's usually at that particular point in time that you see that they will find defects. Now, depending on how significant the defect is, it could be a minor defect such as your final exit is blocked. Remove the things in front that are actually causing the block, and then you've made that particular final exit compliant. But then on the most extreme, you're actually finding that quite a lot of IQPs are sending in reports in lieu for defects on systems, and that becomes an issue, and that becomes a concern for us, because defects don't just happen, and they don't just happen overnight, especially significant defects. So somewhere along the line, the owner and the owner's agent will need to question the IQP as to the significance of, or the degree and level of non-compliance that defect is posing on the system, and address that immediately, and also it will require the owner to actually take an active step in making sure that that system is brought up to a compliant state. So at the end of the day, we have been receiving reports in lieu for defects. We will assess those on a case by case. If we deem that the defect is too significant and it will impact on the performance of that particular system, don't be surprised if we send an RFI or ultimately issue a notice to fix for you to correct that before the next renewal.
So a big takeaway from that is really challenge the contractor. Does the remedial works need to be taken place?
Yeah. So yeah, ask the question: is it going to impact on whether you issue the 12A certificate in order for this year's or the next or the new renewal to be accepted, or can it be taken care of in the next renewal period, etc., etc.
We had one from Charmaine. Please clarify the process for updating the compliance schedule following a building renovation where BWOF systems have changed.
Okay. So Charmaine, any work that is undertaken via consent, your compliance schedule will be covered in whether it needs amendment or whether it needs etc. Whether it doesn't need an amendment, etc. It will all be covered by your code compliance certificate team when the building works are completed, and any changes will be documented in the compliance schedule via that team.
We had another one, fire action notices were changed in 2018, but this doesn't seem to filter down to facilities managers. What is our response?
Yeah, so fire action notices, I'd say, would fall under 15D. So if the requirement for it has changed as per the building code, it would only need to be compliant at the time that it was installed. It's only if you do work after the change came into effect, then you would be required to comply with the code requirement move now. So if
they're in place now and you don't touch anything, they can stay as is.
They can stay as is.
We had a good one from Robert. Why do so many councils interpret the Building Act differently?
I think it's from Auckland Council's perspective is I can't speak for other councils. I'd say it's because the annual building warrant of fitness process is huge. It's a big beast. So your interpretation of the legislation that we're meant to regulate is rather dependent on your area throughout in New Zealand. No one knows except for MB who writes this what their interpretation is, and you just to try and apply it as best you can to your current processes that you have in place or in line with your policies that you have. So
okay, Fiona, do we have any more? Do we have any more on the chat?
We had a couple in from Justin. I think we've covered off the 12A lieu sign off of the BWOF, but do changes to specified systems require a building consent?
Changes to specified systems,
do they require a building consent?
It depends on the extent of the change. So you will find at the back of the Building Act that you have Schedule 1 and Schedule 2, which is exemptions to consents. So it really does depend on what you are doing, but effectively any change to a specified system, you could potentially need or be required to actually apply for a consent.
Is that in terms of, so if we swap like for like, so say if you're swapping the exact same component over for the exact same component, would that need a building consent?
Yeah, so what you're probably touching on, Zared, is Schedule 1, where it says that if you are going, if the replacement is going to be like for like and the work is minor,
yep.
Then you could potentially use Schedule 1 as your catalyst for wanting to make your change to your specified system. And in that case, if that is what you are going to do, then you would not need a consent. However, you do need to also bear in mind that if the change is a significant change, then the obvious choice there would be you would need to apply for a consent.
Thanks, Lupe. One that's come in from Simon: should IQPs inspect pacifier systems, i.e. above ceilings?
Yes, I think they should. And the only reason why I think that they should be inspecting pacifier systems is because these are systems which are naked to the, or invisible to the naked eye. So we can't actually, we could probably see it in the form of a wall or in the form of a door, ceiling, etc., etc. But if they form part of a fire separation, then you really do need to make sure that you are checking them. And if it is above the ceiling, then you need to go into that little manhole or little
pop the tile.
Yeah, pop the tile and just have a look and see and make sure that they're still you know, that no damage has occurred to them, because the more you don't check for systems, especially systems that are hidden behind or in the back of a wall or up in the ceiling, you don't know whether that system will perform when it needs to. So we need to make sure that any passive systems that are hidden need to be checked.
Right, thanks Lupe for that. One here from Suzanne: if there is an addition to a specified system, i.e. installation of a new HVAC system within a large standalone tenancy, within a large facility such as an external mall, but a building consent is not required, what is the best way for the building compliance schedule to be updated? Is this a Form 11 situation?
Maybe you could take that one since you're in mechanical.
Yeah, well, I thought if you were changing the mechanical component, and just like what you just said, that if you're changing the whole and not changing like for like, that would still need a building consent.
It would, yeah.
It would need a building consent.
It sounds, and only because it sounds quite, the work involved is quite significant. So I would possibly find it really difficult to try and work that you would be doing such an extensive amount of work and not require a consent to sign it all off to make sure it's being done properly.
And then if it's consented works, then that would then fall into the existing, that would be an addition to the specified system on the existing compliance schedule. So then you would use a Form 11?
No, if it's under a consent, it will be taken care of by the code compliance certificate team.
Yeah, that point. Sorry, that point. Yeah, that point. I'm just, because you're changing the whole. If you're changing the whole system, you're changing the whole. If the new system's probably not going to be like for like, because your airflows are going to be a lot different. You're going to be changing all the bracketry, the way it sits, especially if it's a large system. It's going to be totally different. So I think that'd fall under a consented process.
Yeah.
Because anything that's load bearing. So.
Yeah. And obviously it will just go from a building consents authority perspective. You will have inspections to make sure it is being done properly and it's being done correctly. After the consented works have all been completed and they apply for a CCC, then the CCC team will obviously go through and make sure that the specified systems, if they have changed, if you've upgraded it from what it was originally, they should also be amending the compliance schedule to document that the system has now changed from what it was, and then implement or insert what the new changes are relating to that particular system.
Right. Hopefully, Suzanne, we've answered your question there. Probably got time for one last question, and we'll try and make it an easier question to answer. From Megan, what does SSSR and BSSR stand for?
So the BSSR is a Building System Status Report, and SSSR is Specified System Status Report.
Oh, so you've done that quickly. And then same again from Megan. I would just like to confirm that a BSSR acts as the same for insurance companies and allowing to occupy the building by staff. No, I'd say that's PCU. But
PCBU?
No. Like notice to prior to consent being given, you can get a occupancy. No,
Unpick for occupancy.
if it's a new building, you haven't yet got compliance sign off.
And which allows you to occupy the building before it's actually got its CCC.
Correct.
Yeah, so that's so you're referring to a certificate of public use.
So CPU.
Yeah.
Q.
Yeah. So a CPU is effectively a process which is allows the building to open and trade while it's actually getting or finalising its code compliance or CCC. And so therefore there will be specific requirements around that, and usually a CPU can be issued from anything between 6 months to a year, but most cases a lot of people just use it just until the CCC has been finalised and everything's all in order, and then send it. So.
But a BSSR wouldn't act in the same way?
No. So a BSSR is, like I said, what the Ministry of Business and Innovation released as being what they would say is a building system status report. It is not the Form 12, so it's not a building warrant of fitness. And it's effectively saying that the building is not displaying a BWOF due to COVID-19, and that was the document, or that is the document that MBIE released that needed to be put on display in lieu of a building warrant of fitness.
Great. Well, that brings us to the top of the hour. And no further questions. I think we've covered everything off. Again, thank you to all our attendees that have joined our inaugural webinar. We trust that you found this highly informative and some food for thought on how you work through with your contractors and building warrant fitness agent, and indeed potentially your clients in terms of building owners. I'd like to extend our thanks to Lupe for joining us today and providing her experience and insight into Auckland Council and the processes by which they work for the delivery of annual building warrant fitnesses, and to my colleague Zared for helping to set this up. Thank you very much. And again, the PDF is available under the handouts. We look forward to advising you of our next webinar in due course. Thank you all. Have a great day.
Thanks.